Right, good afternoon, everyone. My name is Alex Mills, and I'm General Editor of the ICLQ, alongside the Director of BICL, Professor Spiros Maniatis. And we're absolutely delighted to welcome you all to this event, those of you who are here in the room, and the many of you who are joining us online as well. This event is one of the highlights of the ICLQ and BICL calendar because it's an opportunity for us to showcase some of the outstanding research which we're proud and delighted to publish every year. This event has three parts. First, the award of the Early Career Prize and a conversation with the prize winner for about 10 minutes or so. Second, the annual lecture, which will take about 40 minutes or so, with the opportunity for some questions and discussion afterwards. And then this discussion will flow seamlessly into the third part of this event, the drinks reception, which will follow. With sincere thanks, as always, to our fantastic publishers, Cambridge University Press, for their sponsorship of the reception and indeed all the terrific work they do supporting the journal. So we begin with the Early Career Prize. The Early Career Prize is awarded each year to the best article published in the previous year's volume of the ICLQ by an early career scholar. It's decided by the editorial board of the journal, and thanks to the generosity of Cambridge University Press, comes with the award of £250 worth of Cambridge University Press books. And this year, I'm delighted to announce the award of the prize to Dr. Lewis Graham of Wadham College, Oxford, for his article published in volume 72.2 of the journal, Liberty and Its Exceptions. Congratulations, Lewis. Thank you very much. I think we have a certificate to recognize this achievement to begin.
Shall I come to you?
Yeah.
Where's your right-hand side?
Okay. Congratulations.
Thank you. Thank you so much.
All right, and I'm going to sit down for the in conversation bit of this presentation. So, those congratulations again.
Thank you so much.
I wonder if you could start a little bit by, well, telling us, but I'm sure everyone in the room has, of course, read the article, but for those who might need a little reminding, what the article is about, what's its main argument, its main contribution.
Yeah, thank you so much. Thank you, obviously, very much for the prize. It's also really nice to hear that people are reading my output and not just the undergraduate students that I crowbar my research into their reading lists for. The article is about the right to liberty under Article 5 of the ECHR. And it's quite a doctrinal piece. And it's a piece which sort of tries to bring together a few disparate areas of the case law. My main argument that I sort of float there is Article 5 is weird. Article 5 is an odd right under the convention. It's not like Article 2 and Article 3, which are these kind of absolute rights, giving no exceptions, asterisk. Maybe there were some exceptions, but. And it's not like Articles 8, 9, 10, privacy, speech, religion, where we have kind of proportionality is kind of the tool judges use to determine whether there's been a breach of those rights. Article 5 is weird. Article 5's got its own specific exemptions listed in the article. And so students find it quite boring. It's a bit difficult to teach, hard to make it quite exciting. But I think when you do dig in there and you do look at the case law, you find some really interesting things. We see, for example, that what the drafters of the convention thought might be these, universally applicable exceptions to your right not to be detained, what they ought to be in 1950 might not quite match up with the sort of day-to-day realities of policing and, I don't know, a COVID pandemic in the 21st century. And so you've got this really familiar tension between kind of the letter of the law, a strict literal interpretation of what the European Convention says, And then kind of what do judges do when they come across these kind of modern problems? Do judges say sort of, it's our job to apply the letter of the law? Is the judge's job to be a bit more creative? Does a judge have a duty to kind of come to the right moral conclusion and kind of work backwards? And I sort of go through a few different areas of case, and I suggest that actually in more areas than we think, Article 5 isn't really being applied in the way judges are saying they're applying it. They're not really doing what they're supposed to be doing or they're saying they're doing when they're doing Article 5. That might be a good thing, might be a bad thing, probably somewhere in between. But I suggest that if we look at this case law and take it seriously, it opens a whole kind of worms about the convention, how we protect those rights, and the role of judges.
And so I think everyone's often interested in where people get their ideas about writing articles. Did this come out of a sort of sense of dissatisfaction of reading or teaching this case law, feeling like that there was something going on which was unwritten, which was sort of behind the kind of text of the judgments?
Yeah, I think so. I think a little bit at least. We maybe it's just my students who are particularly bored of this topic, but it's easy to get students and everybody excited about religious freedoms, freedom of speech, privacy rights, abortion rights. All of these things are salient in the case law. They're in all the journals. They're in all the judicial sort of discussions, and that's great and important. And like I say, Article 5 is usually sort of resigned to the textbooks. Maybe there's a couple of exciting cases that happen once a decade. But I think these controversies, which are everywhere in the convention, are also there in Article 5. So what I try to do here is kind of tease that out, draw on the existing literature that we have in relation to all these other rights, all these other kind of more exciting areas, or traditionally more exciting areas, and apply them to the Article 5 context. And it makes my job easier to teach it now as well.
You cover a lot of different areas of practice in the piece, sort of from kettling and crowd control, preventive detention, protective detention, armed conflict, and so on. You mentioned COVID-19 before, and that's one of the kind of areas that you look at as well. And the approach, I think, is in particular the European Court of Human Rights took to COVID restrictions, which, if I understand correctly, sort of found them not to be a deprivation of liberty in order not to have to invoke the exceptions. I wonder if you could say a little bit more about the European Court's approach in that context.
Yeah. You've summarized it better than I can. The court comes against this kind of big problem, these massive, unprecedented, that word we're all sick of hearing, restrictions and lockdowns and vaccine mandates and all of these things. And none of that, as far as I can see, as far as the judges can see, can be accommodated by the text of Article 5. Article 5 allows deprivations of liberty for under certain circumstances, and they include things like prevention of crime. And there's something there about the spread of disease, but it's not really phrased in a way which could apply to the convention. And yet, clearly, lockdowns in some European countries were in effect a deprivation of liberty. Now, I think it's a perfectly justifiable deprivation of liberty to stop the spread of a disease that kills lots of people. That's clearly a justifiable, for me, deprivation of liberty. But the convention apparatus doesn't allow you to get to that point. So what did the judges do? They said, this isn't an interference with your liberty at all. I found that quite odd. If you look at the case law, if the police detain you for a couple of hours and say you can't leave your home, and if you leave your home, you'll be arrested, that's a deprivation of liberty. Okay? But if you're only allowed out of your house for 1 hour a day for exercise or whatever it was at the beginning of the pandemic, that is, I just struggle to see how that isn't an interference with your liberty. Again, I stress a perfectly justifiable interference given the exceptional circumstances. But the court can't get to that second stage. It doesn't want to say that all of the lockdowns which happened in Europe for 1.5 years were unlawful. So it just kind of says, no deprivation of liberty in the first place. It's a fudge. Whether you think it's a justifiable fudge or not, up to you, but it's a fudge.
At one level, this is a piece about Article 5, and it's a really close reading of the Article 5 jurisprudence and a kind of interrogation of that case law. But sort of stepping back a little bit, it's also a piece about the role of judges and the sort of limits of judicial creativity and what the kind of appropriate scope is, because I think in the piece there's maybe there's a certain amount of ambivalence that in a sense we celebrate the creative judge who's able to find a kind of practical solution to these cases. But at the same time, there's a kind of challenge to legal certainty, almost even to the rule of law in terms of judges going beyond the text of a very clearly defined convention, clearly articulated convention. And so there's quite important broader lessons in this piece as well, I think, on that sort of tension. Can you say a little bit about that?
Yeah, I mean, I've done that quite annoying academic thing where I raise a lot of issues and say, isn't this interesting, but then don't provide solutions to all of them. But certainly this is sort of something, right? How far you say, okay, lockdown's exceptional. That was kind of, a specific situation where we might let this slide. What about police kettling? Some people might say that's sort of okay. And then we've got another exception, another exception, another exception. And how far are we sort of okay with judges sort of nodding along with these exceptions until actually the core point of Article 5, protection from being deprived of your liberty, except in these apparently exclusive 6 circumstances, before that's just undermined. And there's a worry there. I think some of these cases are not justifiable. I've got great concerns about things like kettling and stop and search. I'm really worried that judges are applying Article 5 in too elastic a way. I think there's some real danger there. Where exactly the dividing line is between sort of pragmatic justice that judges do day in day, human rights judges certainly do day in, day out, and kind of a maladapted, kind of an inappropriate restructuring of the convention. I don't know exactly where that line is, but it's definitely in Article 5, just as much as it is with all of these, Lord Sumption in The Spectator complaining about the unlimited reach of Article 8. It applies just as much to these more traditional rights as it does with these kind of slightly more contestable concepts.
But perhaps, there's lessons for about judges and the role of, about judging the role of judges. Maybe there are also lessons about for lawmakers. In this as well, because the experience of Article 5 sort of suggests that rigidity in lawmaking potentially creates problems down the track as courts struggle to kind of deal with real cases. So maybe there's also sort of lessons in this piece for those writing laws.
Yeah, I think so. I mean, I noted one of the, I guess, nice things about some of the rights and human rights based in UK legislation is judges can interpret them pretty straightforwardly, pretty literally, and then say, well, if we can get a new law, we can pass a new piece of legislation, we can amend this, we can make it more flexible. Obviously, that's really hard to do with one of the core rights in the ECHR. The amendment process is impossible. And this topic is not particularly exciting. I mean, if I was to list 20 things that should change about the convention, despite the fact I've written this article, this probably wouldn't feature in the top 20. It's quite a technical lawyer's law kind of thing. I think it's important, but the chances of, a convention amendment is really, really sort of low. And that's a benefit of the convention system, and it's a weakness of the convention system. And so I guess I'm slightly more sympathetic to what some of the judges in this case are doing, because the judges can't say to a legislator, go and amend this. Here's your absurd result. Lockdowns are all unlawful. Go and change it. Can't really happen in the convention system. This level of flexibility and elasticity, I think, is to an extent more justifiable when you're dealing with something like the convention, but certainly lessons for domestic legislators or systems where you do have more change and updating of the text you're applying. Rigidity 75 years later can be quite constraining.
Thank you. Final question really is, what's next? How does this article sort of fit into your future research plans? Where do you see sort of taking it further? I know you have I think you have a book coming out, which is about the judicial role, more kind of focused on the limits of the judicial role. But yeah, you can say a little bit more about.
Yeah, I'm a big nerd for 2 things. One is human rights law, and 2 is kind of the role of the judiciary. And I guess this piece combines both, though it's more the former, and the book also combines both, though it's more the latter. My research more generally just looks at judicial behavior, how judges do what they do, both national judges in the UK context, judges in the European Court, judges in other courts. The book in particular looks at individual judicial approaches to human rights and other areas. So we know that some judges approach human rights in a very literalist, straightforward way. Other judges are much more, inverted commas, creative with the way they approach human rights concerns. And I don't see that divergence so much in the Article 5 liberty context, but in other areas we really do. So I'm not necessarily planning on spending a career writing about Article 5, although I find it quite interesting, and maybe, you know, a big new case comes out, I'll be writing on that. But I'm much more interested in kind of how judges approach human rights, how judges approach discretion, how judges approach these open-ended, I think Lord Neuberger called them soft, woolly principles of human rights law, how these human beings with their values and their ideas and their ideologies approach these kinds of questions.
That's fantastic. That sounds fantastic.
Good luck for the book.
We're all looking forward to it, and absolutely to the book. So please join me in congratulating Lewis again.
Thank you so much.
Now, if I may again, by way of introducing the annual lecture. Each year, the editorial board of the ICLQ invites one of what it considers to be the most interesting and outstanding contributions of the journal in the previous year to deliver the ICLQ Annual Lecture. And this year, I'm delighted to announce or to introduce the annual lecture to be given by Professor Russell Buchan. Russell is a professor of international law at the University of Reading, with a broad range of research and teaching interests across international legal theory and practice, including UN law, the use of force, humanitarian law, and international criminal law. The annual lecture will be based on his excellent article published in volume 72.1 of the ICLQ, entitled Non-Forcible Measures and the Law of Self-Defense. Congratulations, Russell, and we welcome you to the stage. I'm always nervous when there's applause before the presentation, just in case it's not as enthusiastic as after the presentation. But I have some slides just to help focus the presentation. They're more quotations than particular points, but as I say, hopefully it will help you follow. Well, thanks very much, Alex, for that introduction. Thanks to the ICLQ for publishing the article, for inviting me to deliver this annual lecture, and for Bickle for hosting it. Let me begin by stating as clearly and concisely as possible the article's central claim. I argue that self-defense, as contained in Article 51 of the United Nations Charter and customary international law, is a general right under international law. And as such, it can be engaged to justify all measures necessary to halt and repel an armed attack, including forcible and non-forcible measures, provided they are necessary and proportionate in the circumstances. Now, it's important to highlight that existing literature often characterizes the right of self-defense as a narrowly drawn exception to the prohibition on the threat or use of force, as enshrined in Article 2.4 of the United Nations Charter and customary international law. Now, according to this formulation, as a matter of legal principle, self-defense can only be engaged to justify forcible responses to armed attack. That is, measures that would otherwise constitute an unlawful threat or use of force. And as I argue in the article, this conception of the right to self-defense has become the conventional wisdom. So to demonstrate this, let's take a closer look at the literature. Okay, thanks. For Professor Kelson, as you can see, self-defense is the use of force by a person illegally attacked by another. For Roger O'Keefe, self-defense encompasses only forcible measures.
For Judge Rosalind Higgins, she also adopted this approach in her separate opinion in the Wall Advisory Opinion, when she explained that non-forcible measures, such as the building of a wall, do not fall within self-defense under Article 51 of the UN Charter, as that provision is normally understood. Importantly, the International Law Commission took this view in its commentary to Article 21 of the Articles on State Responsibility, when it explained that the right of self-defense under Article 51 of the UN Charter forms part of the definition of the obligation to refrain from the threat or use of force. Now, you'll notice that Article 21 of the Articles on State Responsibility concerns self-defense and clearly covers non-forcible measures, and I have it up there on the PowerPoint for you. And in fact, in his work as Special Rapporteur for the International Law Commission, James Crawford explained that Article 21 can be invoked to justify prima facie breaches of the principle of sovereignty, treaties of amity, and he identified a number of others. But significantly, Article 51 of the UN Charter and Article 21 of the Articles on State Responsibility should not be confused. The International Law Commission casts Article 51, and I would agree, as a primary rule of international law that justifies forcible responses to armed attacks, whereas Article 21 is presented as a secondary law of international law that precludes wrongfulness for incidental breaches of international law that occur as a result of Article 51 being engaged. I hope that's illustrated from the following quotation from the International Law Commission's commentary to Article 21. It says, self-defense under Article 21 may justify non-performance of certain obligations other than that under Article 2, paragraph 4, provided that such performance is related to the breach of that provision. So this makes clear that Article 21 cannot be relied upon independently of Article 51 to justify the use of non-forcible measures to halt and repel an armed attack. Article 21 is parasitic on Article 51. Now, I'd be remiss if I did not recognize that some commentators have already advanced the argument that the right of self-defense as a primary rule covers non-forcible measures. For example, Sir Derek Bauer and Professor Christine Tams have made this argument. However, they do so only in passing, the reason being that their publications focus on other aspects of the law of self-defense. In fact, Sir Derek Bauer's claim comes in a solitary sentence in the introduction to his famous monograph on self-defense, and Professor Tams's claim appears in a footnote in his European Journal of International Law article examining the ICJ's Wall Advisory Opinion. Understandably then, neither commentator puts forward any theoretical or doctrinal justification to support their claim. So in this brief introduction, I'd like to think that I've identified the importance of the article, but also the originality of that article, and demonstrating that the right of self-defense covers non-forcible as well as forcible measures is important, because many states may want to undertake non-forcible measures to fight off an armed attack that are otherwise unlawful. For example, a state may carry out cyber operations that run into conflict with the principles of sovereignty and non-intervention. Blockades and security wars may violate international human rights law and international humanitarian law, and trade restrictions may infringe international trade law. I will return to some of these examples later in the presentation, but for the moment, the key point is that non-forcible measures may be an effective way for states to repel an armed attack. So in light of this, I'll now move on to demonstrate, hopefully, that as a matter of lex lata, as the law stands, the right of self-defense can be engaged to justify all measures necessary to fend off an armed attack. And to do so, I examine the origins of the right to self-defense under customary international law, the text and the structure of Article 51, and state practice of Article 51. So turning first to customary international law. Well, Article 51's description of self-defense as an inherent right refers, as the International Court of Justice explained in the Nicaragua judgment, to the pre-existing customary law basis of this doctrine. As we know, the Charter seeks to integrate the right of self-defense into the UN system and make it suitable for the collective security era. So an inquiry into the customary practice of the right of self-defense prior to the adoption of the UN Charter is essential if we are to understand the content of this right under contemporary international law. Now, the right of self-defense originally took the form of a duty of self-preservation, and there was no doubt that this duty conferred an almost unlimited right on states to act as they considered necessary to protect their essential interests. While this natural law duty evolved into a customary right of self-defense during the mid to late 19th century, which involved various restrictions being placed on the right of self-defense, necessity, proportionality, a review of state practice reveals that states did not limit the right of self-defense to the use of forcible measures exclusively. I don't think I have the time this evening to go through the various examples of state practice that I examine in the article. I'd encourage you to look at the article and look to that state practice. But let me give you one well-known example for illustrative purposes. As many of us will know, in 1837, British forces entered US territory to destroy the Caroline, which was a steamer being used to transport war material to groups in Upper Canada who were rebelling and revolting against British rule. British forces killed at least one American national and fired the Caroline and set it sail famously over Niagara Falls. And the use of force, scholars in the room will know that this gave rise to protracted diplomatic correspondence between American and British officials. Now, what's important for the present purposes, the Caroline is often discussed in the context of preemptive self-defense, but what's important for present purposes is that this correspondence between American and British officials indicates that the UK, they didn't invoke the right to self-defense to justify the use of force against the US, but instead, and to use the UK's words, to justify non-consensual entry into the territory of the independent state. And as the US Secretary of State explained, I won't read the whole quotation, you can do so for yourself, but you can see that the protest concerns respect for the inviolable character of the territory of independent states. Now, of course, the use of force is bound up with this incident. The UK used armed force in the territory of the US. However, the UK did not engage the right of self-defense to justify the use of force because, as Professor Ian Brownlee demonstrates, the principle of non-use of force did not establish itself in customary law until some point he identifies between 1928 and 1945. Thus, prior to this date, military interventions were assessed according to other rules of international law, such as the principles of sovereignty and non-intervention. So what this shows then is that the right of self-defense predates the principle of non-use of force. And that critically, these provisions developed at different points in time in a different context. So self-defense developed as a customary right many decades before the principle of non-use of force was grafted onto international law. And consequently, there is no inextricable historical legal relationship between them. And as I will now show, the general nature of the right of self-defense has been maintained since the inception of the United Nations. And this is evident from the text and structure of the UN Charter, as well as state practice. So first, let's look at the text of Article 51. I'm sure we're all very familiar with it, particularly that first sentence. It explains, nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs. Clearly, there's nothing in the text of Article 51 to suggest that it only applies to forcible defensive measures. Moreover, the interpretive maxim in the greater has always included the lesser. It's an interpretive maxim that's used by national and international courts to give effect to the ordinary meaning of treaty terms. So if states can use force to repel an armed attack, which they clearly can, uncontested that they can, logic must dictate that they can also use non-forcible measures to repel it as well. In the greater is included the lesser. In fact, Israel invoked this concept before the General Assembly in 2003, when responding to claims that its security war breached international human rights law and international humanitarian law. As we can see, Israel stated that if Article 51 covers forcible measures, it must also cover non-forcible measures, such as the construction of a security wall. As the quotation says, self-defense must surely recognize the right to use non-forcible measures. Now let's look to the structure of the UN Charter. The structure of the treaty can be used to interpret the meaning of its provisions. And this is important in the context of the current discussion, because Article 51 appears in Chapter 7 of the UN Charter, whilst the principle of non-use of force is contained in Chapter 1. As we know, Chapter 1 regulates the UN's collective security system. Article 51 is the final provision in that chapter and operates as an emergency provision that permits states to engage in defensive action until the Council adopts the measures necessary to maintain international peace and security. Importantly, the preparatory materials reveal that states saw self-defense as an exception to the UN's collective security powers, rather than an exception to the prohibition on threat or use of force. As one example, again, in the article, I give other examples from the travaux, but commenting on a draft of Article 51, the Chinese delegate to the San Francisco conference explained, and to quote, that this article, Article 51, amounts to an exception to the enforcement arrangements decided upon by the Security Council. So structurally, there's no indication in the UN Charter that Article 51 is tied to or bound up with Article 2.4. Rather, they are freestanding provisions. Now let's examine the state practice of Article 51. First, let me turn to regional arrangements. Again, I'll give one example for illustrative purposes, but others are available as I explained in the article. In 1945, the North Atlantic Treaty was signed and NATO was thereby established. The critical provision of this treaty is Article 5, which establishes a self-defense pact. As hopefully you can see, I've underlined, Article 5 indicates that this provision is formulated consistently with Article 51 of the UN Charter. And again, the travel of the North Atlantic Treaty confirmed this. This is important because the second part of Article 5, also underlined, makes clear that collective self-defense action can include the provision of assistance that each member deems necessary, including but not limited to the use of armed force. So clearly envisaging self-defense being a general right rather than just an authorization to use force. There are other regional arrangements. Again, I identified them in the article, but I think, and some of them reproduce almost verbatim Article 5 of the NATO Treaty. I think what that shows is this broad geographical spread of states taking this provision. Moving forward, in April 1982, Argentina invaded the Falkland Islands, which is territory under British rule. The UK invoked Article 51 of the UN Charter and undertook military action against Argentina. And at the request of the UK, a number of states imposed import embargoes, comprehensive import embargoes against Argentinian goods, which ran into prima facie conflict with their commitments under the General Agreement on Trades and on Tariffs and Trade, the GATT. Some commentators argue that these prima facie and lawful measures were justified on the basis of Article 21 of the GATT, which, as you probably know, permits members to depart from their obligations under the GATT where necessary to protect their essential security interests. But this argument, for me, is unconvincing for two main reasons. First, these states explained that any infraction of the GATT was justified on the basis of, and I quote, their inherent rights, which suggests that the legal basis for these measures was located outside of the GATT and in general international law. The use of force scholars will be immediately familiar with that concept of inherent right. I will come back to it in a moment. But the point is, it indicates that their legal basis was located beyond Article 21 of the GATT, beyond the GATT more generally. Second, as well as violating the GATT, the embargoes breached obligations owed to Argentina under various sectoral agreements that were not covered by the GATT. And evidently, Article 21 cannot be invoked to justify such prima facie breaches, which means their legal basis must have also resided elsewhere. Now, recognizing that the embargoes were not undertaken pursuant to Article 21 of the GATT, some commentators suggest that they were deployed as collective countermeasures on the basis that Argentina's armed attack amounted to a breach of an erga omnes rule, namely the principle of non-use of force. However, the language used indicates that the embargoes were not deployed as collective countermeasures, because even if this doctrine exists in customary international law, I don't think it does, but even if it is, for the sake of argument, it cannot be described as an inherent right. Self-defense, however, is uniquely described as an inherent right in Article 1. And so the use of this term of art points to self-defense being the legal basis for the embargoes, collective self-defense. That self-defense was the legal basis for these non-forcible measures, is also supported by the following statement by the Canadian Secretary of State. Again, I won't read the whole quotation for you, but you can see it there. So the Secretary of State explains that the UK has had recourse to self-defense, and acting in pursuance of that position, we have banned the export of war material. impose similar kinds of restrictions with respect to entry of Argentinian imports to Canada. So again, clearly the right of self-defense, collective self-defense had been identified. And finally, these states reported their deployment of the embargoes to the Security Council, which implies they were taken in collective self-defense of the UK because Article 51 requires defensive measures to be reported to the Council. Admittedly, these states in the letter that they sent to the Security Council did not expressly identify Article 51 as the legal basis, but it's well established that defending states do not need to do so. All that is required is that they notify the Security Council that defensive measures have been taken. And these states did this when they explained to the Council that their measures were undertaken in response to what it refers to Argentina's unlawful invasion of Falkland Islands. This language, coupled with the fact that the UK had requested third states to help it rebuff Argentina's armed attack, points to collective self-defense as being the legal basis for these embargoes. Another example of a state relying on the right of self-defense to justify the use of non-forcible measures to repel an armed attack is, as already mentioned, Israel's construction of a security wall in the early 2000s, which arguably breached international human rights law and international humanitarian law. Even though the ICJ found that Israel could not rely on the right of self-defense, because the armed attacks could not be contributed to a state and emanated from occupied territory, and perhaps for some, a security wall such as this is a use of force within the meaning of Article 2 for the UN Charter. For me, it isn't, but some commentators take that view in the literature. The point is that Israel saw the wall as a non-forcible measure, which could be justified as an act of self-defense under Article 51. And I've reproduced the key quotation for you. So security defense has proven itself to be one of the most effective non-violent methods for preventing terrorism in the heart of civilian areas. Defense is a measure wholly consistent with Article 51 of the Charter. And as a final example, let me turn to cyber operations. I can't not mention, say, cyber operations, a topic close to my heart at the moment. In the digital age, states may want to fight off an armed attack by conducting cyber operations. Under what circumstances cyber operations amount to a use of force is hotly contested. But either way, the threshold is high. The cyber operation needs to produce either offline physical harm, or if only online harm is caused, the effects need to be serious. Whatever approach is taken, the reality is that only very few cyber operations will contravene the prohibition on use of force. However, these cyber operations may fall foul of other international legal rules, such as the principles of sovereignty and non-intervention. If taken to fend off an armed attack, can they be justified on the basis of self-defense? Well, some states have developed the doctrines of active self-defense and defend forward to confront adversaries in cyberspace. Again, let me focus on just one example, the defend forward strategy that's been put forward by the US Department of Defense. The DoD, as you can see, explains that it seeks to preempt, defeat, or deter malicious cyber activity. Our primary role is to defend forward by leveraging our focus outward to stop threats before they reach their targets. For me, the DoD's language indicates that when non-forcible cyber operations are undertaken in response to an armed attack, the right of self-defense can be relied on. After all, the strategy is called defend forward, and its aim is to stop threats and to protect targets. You will also see on the PowerPoint a quotation from NATO's Secretary General. To the extent that Article 5 of the North Atlantic Treaty covers non-forcible cyber operations, so too must the right of self-defense under Article 51 of the UN Charter, because, as said previously, Article 5 and Article 51 are aligned. So hopefully that evidence convinces you, or at least raises the argument in your mind that the right of self-defense as a primary rule can be engaged to justify non-forcible as well as forcible measures. Moving forward, most commentators claim that where a state suffers an armed attack and responds with forcible measures that are prima facie unlawful, it must rely on the doctrine of countermeasures to shield itself from international legal responsibility. So, for example, in rejecting Sir Derek Bowett's claim that self-defense covers economic sanctions, Professor Sicilianos explains that if they are in themselves unlawful, they will be justified as countermeasures. Again, I cite much more of the academic literature in the article which broadly supports that type of claim. As we know, countermeasures are otherwise unlawful acts that are lawful because they are designed to implement state responsibility for prior breaches of international law. Where a state has fallen victim to an armed attack and that attack constitutes a breach of international law, namely the principle of non-use of force, the victim state's reaction may qualify as a countermeasure. However, my argument is that where a state responds to an armed attack with an otherwise unlawful non-forcible measure, the doctrine of countermeasures will rarely provide a suitable or appropriate legal basis. And as I now explain, there are compelling conceptual, theoretical, and doctrinal reasons for why such responses should be characterized as an act of self-defense rather than a countermeasure. First, conceptually, countermeasures and self-defense are important self-help mechanisms given the decentralized nature of the international legal system. However, they are very different types of self-help mechanisms. Countermeasures are law enforcement measures insofar as they are designed to induce wrongdoing states into compliance with international law. By contrast, self-defense permits victim states to protect themselves from violent attacks. Self-defense therefore concerns self-preservation, and in this way evokes a warlike paradigm. Consequently, it's conceptually erroneous to describe non-forcible responses to armed attacks as countermeasures. Instead, this type of reaction is more appropriately characterized as self-defense. Second, theoretically, international law, like most legal systems, categorize defenses as either justifications or excuses. A justification defense arises because of the property of the act, whereas an excuse defense arises because of the property of the actor. Thus, justification defenses describe conduct that is warranted and therefore lawful per se. Excuse defenses, on the other hand, concede that the impugned conduct is unlawful, but maintain that, given the exigencies of the situation, the state is not to blame for its actions, and consequently, legal responsibility should not be assigned. Now, there's no doubt that self-defense is a justification. It's an inherent right, as Article 51 states, and the International Law Commission explains that when Article 51 is invoked, defensive action does not even potentially breach the non-use of force principle. Self-defense is a justification. I don't think any of us would disagree. By contrast, countermeasures, in my view, constitute excuses rather than justifications. A state can take countermeasures because its legal rights have been infringed, and on this basis is exceptionally permitted to engage in otherwise unlawful conduct in order to implement the responsibility of the wrongdoing state. Thus concede it's the properties of the actor, namely the injured state that's been wronged, that excuses state responsibility for the employment of a countermeasure, rather than countermeasures being justified on the basis of its internal properties. So why does this distinction matter between justifications and excuse? Well, first, it has significant political implications for a state's standing and reputation in the international system. In short, it's far preferable for a state to claim that its behavior is justified and therefore lawful ab initio than to admit that it breached international law, but then assert that its responsibility is excused given the exceptional nature of the circumstance. I think probably Professor Vaughan Lowe puts it best, or at least most eloquently. The distinction between justifications and excuses is the very stuff of classical tragedy. No dramatist, no novelist would confuse them. No philosopher or no theologian would conflate them. You're much better off advancing a justification rather than an excuse. But as we all now see, characterizing self-defense as a justification and countermeasures as an excuse also has really important legal implications. So third, doctrinally, the legal regimes regulating countermeasures and self-defense differ critically in a number of important respects. First, where a wrongdoing state breaches a bilateral obligation owed to an injured state, the latter state cannot invite non-injured states to take countermeasures on its behalf, a doctrine that's often referred to as third-party countermeasures, so not collective countermeasures, but third-party countermeasures. By contrast, where a state falls victim to an armed attack, it can request third states to take defensive measures on its behalf, a doctrine known as collective self-defense, and it's affirmed by Article 51, as we all know. The reason for this is because, as a justification, self-defense is lawful per se. and can therefore be extended to others. By contrast, an excused offence, as an excused offence, countermeasures are personal to the actor and cannot be passed on or don't flow down to third parties. So for this reason, it's better to frame a non-forcible response to an armed attack as an act of self-defense, because it opens up the possibility of inviting third states to assist in repelling an armed attack, a possibility that does not exist with regard to countermeasures. Second, being designed to implement state responsibility for breaches of international law, countermeasures can only be taken against states. Countermeasures cannot be taken directly against non-state actors. This comes out very clearly in the ILC's articles on state responsibility and its commentaries. But as history shows, non-state actors such as armed groups can launch violent attacks against states and do launch violent attacks against states. This means that where states resort to non-forcible measures to counter armed attacks by non-state actors, they cannot rely on the doctrine of countermeasures. But critically, these problems do not arise in the context of self-defense, because at least in my view, the right of self-defense can be engaged directly against non-state actors. A fairly big claim, but I think there's sufficient support within Security Council jurisprudence and state practice. So if we do not accept that self-defense covers non-forcible measures, and we know that countermeasures cannot be taken against non-state actors, a gap in protection emerges. Recognizing that self-defense covers non-forcible measures closes this gap. Third, countermeasures are only available in response to prior breaches of international law. There's no such thing as ancillary countermeasures. Thus, where a state is subject to an imminent armed attack and wants to take countermeasures to prevent it, it cannot rely on the doctrine of countermeasures. But self-defense can be relied on. There is disagreement about how mature a threat has to be before self-defense can be invoked preemptively, but most agree that imminent threats are covered. Now, you may say that an imminent threat of an armed attack is an unlawful threat of force, and thus a state taking non-forcible measures against an imminent threat can rely on the doctrine of countermeasures. But armed attacks do not automatically and necessarily constitute unlawful use of force. The armed attack threshold describes a factual event, grave violence and armed attack against the state, rather than being a legal rule capable of violation. So consider the situation where a non-state actor commits an armed attack, or where a non-state actor is the source of an imminent threat of an armed attack. Most of us agree that there would be no breach of the principle of non-use of force. Consequently, the doctrine of countermeasures is unavailable in that situation, but the right of self-defense is. So unless we recognize that self-defense covers non-forcible measures, how can a state protect itself from an imminent threat of an armed attack by non-state actors? The doctrine of countermeasures simply doesn't help there, whereas self-defense does. Fourth, the articles on state responsibility required injured states to call on wrongdoing states to comply with their legal obligations before countermeasures can be taken, summation, and to notify them that countermeasures are about to be taken before doing so. Exceptionally, injured states can dispense with the notification requirement where urgent countermeasures, to use the ILC's language, are necessary to preserve their legal rights. Here, the obligation shifts to the injured state to demonstrate why notification is not possible given the circumstances. Patently, summation and notification are unrealistic where an armed attack is raining down on the victim state, because first and foremost, it's looking to protect itself from the armed attack. Moreover, such requirements are problematic because putting an aggressor on notice that defensive measures are about to be undertaken may undermine the effectiveness of the riposte. For these reasons, and unlike countermeasures, the law of self-defense does not require defending states to call on aggressors to put an end to the armed attack or notify the aggressor before self-defense is undertaken, or at least demonstrate why notification is not possible. So again, it's apparent that the doctrine of countermeasures is not a good fit where a state is using non-forcible measures to respond to an armed attack. Fifth, the articles on state responsibility require that countermeasures must be reversible as far as possible. And the reason for this is because the purpose of countermeasures is to restore the legal status quo. When it comes to self-defense, there's of course no requirement that defensive measures have to be reversible as far as possible. The state defending itself, its behavior is justified, so there's no requirement of reversibility. Sixth and finally, countermeasures in self-defense must be proportionate in order to be lawful. Countermeasures do not have to be in kind, but they must be commensurate with the injury suffered, taking into account the gravity of the internationally wrongful act and the legal rights in question. So the proportionality principle requires a balance to be struck between the harm suffered by the wrongful act and the harm inflicted by the countermeasure. As sort of an analysis of the quantity of the harm, of the type, the nature and scope of the legal rights to be affected. In the context of self-defense, some commentators maintain that the principle of proportionality also requires a quantitative assessment of the harm caused by the defensive action. In short, their argument is that defensive action is disproportionate where the harm inflicted on the target state, third state, civilians, the environment, goes beyond what is needed to repulse the armed attack. In my view, this is a misreading of the law of self-defense. In the jus ad bellum context, the only restriction imposed by the principle of proportionality is that victim states do no more than achieve the specific objective of defending themselves. Whether the harm inflicted is within permissible limits is decided by other international regimes, such as human rights law, humanitarian law, and environmental law. So this means, importantly, that the principle of proportionality in the context of the law of countermeasures is more demanding than it is in the context of the law of self-defense. And the reason for this is because countermeasures are exceptional measures designed to restore law and order within the international community, whereas self-defense is an inherent right of victim states to defend themselves against grave violence. So again, it's not appropriate to characterize non-forcible responses to armed attacks as countermeasures. Okay, let me conclude briefly. So I sought to demonstrate that self-defense is a general right under international law, and as such, it covers forcible and non-forcible measures. I've also sought to demonstrate why the law of countermeasures cannot suitably or appropriately accommodate non-forcible responses to armed attacks. Fundamentally, the crux of the matter is that countermeasures and self-defense are very different doctrines. Countermeasures, law enforcement, self-defense, self-preservation. It gives rise to all of these differences and complexities. Now, the benefit of characterizing self-defense as a general right is that it enhances the effectiveness of self-defense by broadening the response options available to states, to victim states in particular. In short, it enables them to confront armed attacks with a range of non-forcible and forcible measures. Some of you may be concerned that this argument represents an attempt to expand the law of self-defense, and it falls into a wider, worrying trend by some states and scholars to try to relax the conditions circumscribing the right of self-defense. And I share concerns over expansive interpretations of the law of self-defense. But in this presentation, I have not sought to relax the well-accepted conditions limiting the right of self-defense. There needs to be an armed attack. The response needs to be necessary, needs to be proportionate, and your right of self-defense comes to an end when the Security Council takes the measures necessary to maintain international peace and security. I've not sought to tinker with those restrictions at all. In fact, I believe that my argument can actually help de-escalate crises. Construing self-defense as an exception to the principle of non-use of force would require victim states to use force to resist armed attacks, which runs the risk of unnecessarily aggravating crises if non-forcible measures would be sufficient to counter them. So, the reading of the law of self-defense that permits the use of non-forcible as well as forcible measures is sound as a matter of international law, but also of international policy. I think I'll leave it there. Thanks, Alex.
Wonderful. Thank you very much. Russell, I think, has been kind enough to offer to take some questions. We can take questions from in the room, and also for those online, you can post questions using the question and answer facility. I'll have to read out those questions. But I'd invite, if there's anyone in the room who'd like to start things off.
Thank you. Just listening to what you were saying at the end about countermeasures, a huge amount of ink and angst is being spent at the moment about, on the question of whether, for example, it's possible to seize sovereign states' assets, for example, in response to aggression. We know what we're talking about here. And much of that is focused on whether it can be justified on the basis of collective countermeasures, etc., etc. Presumably, on your argument, you needn't worry with all of that. It would just be a straightforward example of collective self-defense if you chose to expropriate en bloc, although presumably the downside of that is you would actually have to admit that you're acting in collective self-defense. And so presumably that's the real difference between, and you did stress the, if you like, opening up a broader range of response for the victim state, but perhaps the countermeasures route is still more attractive for non-victim states who want to act perhaps in solidarity.
So thanks for the question. It's a good question. It's something that I thought about a lot in the context of the paper. I mean, on the one hand, there may be some sanctions or many sanctions that have been undertaken which simply don't breach international law in the first place. So therefore, they don't require a particular justification. So they're just lawful per se, which then gets us into the complex topic of unilateral restrictive economic measures and their relationship with various rules and regimes of international law. So I think that muddies the water when we're trying to look to what states are saying, because some states may not be giving a legal justification as either countermeasures, collective countermeasures, or collective self-defense, because they just see it as lawful. So that doesn't help people like me that's trying to put things in particular boxes. But yes, I agree exactly with what you say. I've been following some of the academic literature that's been published, and those going down the collective countermeasures routes, I find it's a bit of a Pandora's box in terms of trying, first of all, just to establish that the doctrine is reflective of customary international law. You know, my analysis of the topic would say, I mean, I'm working on cyber in particular, so there's been lots of national positions published on the application of international cyberspace recently, and collective countermeasures often feature in those national positions. You have some states, Costa Rica a couple of years ago, saying it's certainly part of customary international law, but you have states such as Canada saying quite expressly that the state practice in opinion juris isn't there, and you know it's that doctrine is very much contested and divided. So that's an upward struggle just to get to the doctrine of collective countermeasures. And yes, as you say, even if you can establish it as a doctrine, you know, because countermeasures are law enforcement mechanisms, it's surrounded by all of these. I only identify, actually in the article, I go into it more deeply, but also I identify more of the restrictions around countermeasures. It's incredibly onerous to demonstrate that. I mean, if you think about proportionality, how do you measure that in the context of collective countermeasures, and particularly the way proportionality is defined by that doctrine? So my approach would be, you can use collective self-defense there, and it can cover some of those non-forcible measures. And I take your point that may open up other difficulties, but I don't think it should put us off from recognizing the utility of seeing self-defense as a general right.
Any other questions? I'll take one online perhaps, then I'll come back to you next. So we have a number of questions online, one from Harold, for example, who asks about the relevance of the practice with regard to the construction of a wall in Palestinian territory, given that that was a context of occupied territory rather than a use of force by another state against Israeli territory. Is Article 51 really relevant in that context? What's your sort of comment on that?
I mean, it's it's an important question, and I think we've all been following the literature on the blogs and in other forums on this. In my view, self-defense is under Article 51 is a primary rule of international law, and you can there's all different arguments about occupied territory, is Palestine a state, and how does this affect all of those legal analysis? For me, self-defense is a primary rule. It can be engaged, it can be a political justification, it can be a moral justification, it can be a legal justification. As long as the criteria for self-defense are met, there's no armed attack, and so on and so forth, ones that I've identified previously, the response is necessary and proportionate, then it can be engaged. So whether the threat is emanating from occupied territory or not from occupied territory, whether it's from a state or from a non-state actor, and so on and so forth, to me, isn't materially relevant to an international assessment of the availability of self-defense.
Thank you. I think there was a hand up, the gentleman there.
Hello, thank you very much for an interesting talk. I'm struggling with how a state can attempt to defend itself by defining an organization in terms of another state. And I'm thinking of Hamas and saying that Hamas is being funded by Iran, and therefore you can attack Hamas. And I'm just wondering about that crossover with Article 51. I just wondered if you had anything perhaps to say about that.
I mean, the way I'd see it is, if a state falls victim to an armed attack, a state can defend itself in a way that's necessary and proportionate, and until the Security Council takes control of the situation. So, if Hamas is it's obviously a non-state actor, it's an armed group. The state can defend itself against that particular actor. Whether self-defense can be exercised against other actors, for example, Iran, and we see this coming up, I think, with regard to action taken against the Houthis, which arguably are heavily supported by Iran. At what point can self-defense then be taken against Iran? Well, the question then is about authorship of the armed attack. Who is the author of the armed attack? As I said, for me, the identity of the author of the armed attack is not relevant. State or non-state actor. One famous use of force scholar once said to me, who were named, it doesn't matter who commits the armed attack, state, non-state actor, animal, or alien. If you are attacked, if you are subject to grave violence, you can defend yourself. And the question then, it's necessary proportionality and to Security Council involvement, but an important question with regard to Hamas and the Houthis is, who is then behind that particular attack? One view is that you need attribution under the law of state responsibility, in particular the Article 8 effective control. For me, Article 8 is about attributing legal responsibility, who's legally responsible. When we're talking about the use of force and self-defense, the jus ad bellum, the question is who is committing the armed attack? And I don't think that the effective control test is appropriate there. For me, and I think if you look to the definition of aggression, it talks about substantial assistance in order to determine authorship. Now, I'm certainly not saying that Iran has met that test of substantial assistance in the context of the Houthis. I realize that could really escalate things, and it's very, it's about the facts. Is there that substantial assistance? But for me, the important point is determining authorship isn't about effective control, which is notoriously high, almost impossibly high if you look at some of the ICJ jurisprudence. So I don't know if that answers your question.
It's very helpful, thank you.
I have another question online. It's a question which really comes from two different questions, one from Artem and one from Patrick. And they're both asking about the relevance of your presentation in relation to the conflict in Ukraine and the question of the seizure of Russian assets. Whether your argument might be a justification for Russian assets to be confiscated and used for the purposes of aiding in Ukraine's self-defense. Whether these would be non-forcible measures of self-defense, the confiscation of those assets.
I mean, I think, by the end of the presentation, you could be, say quite safely that my view is that those types of measures, if indeed they run into conflict with international law, I see some colleagues in the room who I know, looking at Daniel in particular, who works a lot on sanctions. And, I think, as I said to Sir Malcolm, in response to Sir Malcolm, it's not necessarily that every unilateral restrictive economic measure is going to be a breach of an operative rule of international law. It may just simply be retortion, in which case, why you need to go to countermeasures and satisfy all these, onerous criteria, or indeed go to self-defense. Assessing proportionality, is going to put an obligation on the state that's taking those measures. They could just simply be lawful. If they do run into conflict with the non-intervention principle or any other operative rule, then yes, as I said to Sir Malcolm, self-defense and collective self-defense could be very useful there. As I said, at the moment, perhaps I'm not following as closely as I should be. I'm not sure what states are saying there. Are states going down, it's simply retortion? Are states being pushed to develop the doctrine of collective countermeasures? Hopefully, states may look to my article and think, well, you know, collective self-defense is a much better way to go. But yeah, it's I think that state practice is quite muddy at the moment.
Thank you. Yes, there was a question.
Thank you for the presentation. Actually, it's an interesting issue that you presented because from where I come from, actually, it's the other side. I mean, the issue on whether non-forcible measures can constitute an armed attack. I'm from the Philippines, by the way. But the second sentence in Article 51 of the UN Charter talks about the reportorial requirement to the UN Security Council. So if there would be non-forcible measures of self-defense, would these measures still necessitate reporting it to the Security Council?
So on the second question, I can answer easily. Yes, it's falls within Article 51. It's defensive action, and therefore the reporting obligation would be required. I mean, I think there's an interesting question there about what exactly the reporting obligation is, what it means to report, how you report. Do you provide updating of the self-defense action? Must you provide a legal justification in the Article 51 report? I think lots of those, if you don't report, what's the impact upon self-defense? I think there's some really interesting questions around that. But yes, if you take non-forcible measures, it has to be reported to the Security Council. Your other question is very interesting to me. I mentioned Sir Derek Barrett's very famous monograph on self-defense. Actually, one of the main objectives, or at least I think what that book by Manchester University Press is now most known for, is that Sir Derek advanced the argument that the concept of armed attack just appeared in Article 51, and prior to 1945, when the United Nations was adopted, the United Nations Charter was adopted, you didn't see the concept of armed attack appearing in the law of self-defense. And Sir Derek suggested that self-defense could be invoked as under customary international law in a broader range of circumstances than an armed attack. For example, when necessary to protect essential security interests. That's not an argument that I've needed to grapple with in the paper at all. But if that's something you're interested in, then you probably find Sir Derek's book useful there. But yeah, under Article 51, an armed attack is well, I say clearly grave violence. The US is very much on record saying that any use of force is an armed attack, but I think most see it as being a grave use of force.
Any other questions in the room? And perhaps I'd like to ask a question if you don't mind. So can I press you a little bit on so one of the points you made, which is that countermeasures are a kind of poor fit for what states are doing when they adopt defensive sort of measures. You described countermeasures as a law enforcement paradigm, whereas self-defense is, I think you described as a protective paradigm or a war paradigm in one sense. And I just wanted to kind of press you a little bit on that, because ultimately the purpose of self-defensive measures is restorative in much the same way as countermeasures, that it has to be to restore the status quo, right? The self-defensive measures, although they involve a war paradigm, ultimately aren't they subject to the same kind of constraints as a countermeasure would be in that sense?
For example, in relation to notification or reversibility?
No, in relation to what would satisfy the requirements of necessity and proportionality in terms of an act of self-defense, and what would require what would satisfy the sort of same requirements in relation to countermeasures?
Yeah, I mean, that's a good question. I mean, two parts to my answer. The first would be that there can be overlap between the countermeasures and the doctrines of self-defense. So, it's not binary. There could be overlap there. But to answer the sort of the nub of your question, as I say, I see self-defense and countermeasures as, being very different doctrines for the reasons that you've just summarized. And for that reason, there are critical differences in the way in which those doctrines are formulated. So as I said, they have very different conditions and requirements. Even where there are some similar requirements between countermeasures and self-defense, necessity or proportionality, I think proportionality is the best example of that. They have been, proportionality doesn't have a uniform concept in international law. It appears, say, responsibility, human rights, humanitarian law, and all these different regimes. But it's interpreted differently by states, and the reason it's interpreted differently is because the doctrine is trying to address a different type of harm. Countermeasures, it's legal harm and it's restoring the legal status quo, whereas self-defense is about preserving, I think as the ICJ said, preserving the survival of the state, or where the survival of the state can be under threat. And for that reason, those concepts have been interpreted differently. So as I say, in countermeasures, it's about understanding the legal rights affected, the quantity of the harm of the countermeasure. Whereas when you're talking about self-defense, it's about protecting the survival of the state. The proportionality doesn't require those types of wider considerations. So in that way, they're very different. I mean, if you exercise self-defense, it's a two-order thing for me. I said, first of all, is it lawful as a matter of the law of self-defense? And then you move on and look to how the self-defense is exercised and whether it's compatible with IHL would probably be a very good example there. But, those differences in how we define those doctrines is really underpinned by the fact that they are very different doctrines speaking to very different types of threats.
Thank you. Any other questions in the room? Yes. Yeah.
Thanks very much. Really interesting talk with some obviously very practical consequences. My question is, why do you think this is a novel idea? Is it a result of collective amnesia? Is it poor education of lawyers who end up in government practice, or is there a more sort of principled objection to the ideas that you're proposing?
So my question to you would be, before you read the article, before you just heard the presentation, did you think that self-defense was an exception to the prohibition on use of force, or did you think it was a general right?
I'll hedge my bets. I didn't think it was an outrageous idea, but I guess if you're asking me to answer the question myself, I guess we collectively are taught about self-defense in the context of Article 2.4. So that's perhaps where it comes from. But I was curious as to whether you thought there were more principled objections from states.
Yeah, it's another good question. When I got to the end of writing the article and having subsequently discussed it with people who've read it, I thought to myself, so what? Isn't this? I mean, in my view, isn't it obvious that self-defense can include non-forcible measures? I mean, really, the motivation for the article is because I'm a use of force scholar. First and foremost, my heart is very much on the jus ad bellum. That's where I spend most of my time. And reading the famous textbooks, I'm sure you'll be familiar with those use of force textbooks, it's that this dogma had emerged that self-defense was inbuilt into 2.4, and it was a justification for the use of force in itself. So that was really the motivation for the article. Why that is the case, why that dogma emerged. I mean, I think part of it is that self-defense is typically engaged to justify use of force. That's where states really see the utility of self-defense. It does permit that exceptional use of force in a way that not many other rules. Of course, you have Security Council authorization and humanitarian intervention, depending on how you see things. So perhaps that resulted in sort of this fusion of 2.4 and 51. And perhaps it just became affirmed over time. Hopefully, I've contributed a little bit to dispelling that. As I say, I think the evidence is there, and also, as I said at the end, I think it's sound as a matter of policy as well.
I have a question from someone online, which maybe as an interesting follow-up, because it raises a possible policy concern. So the question is from someone identifying themselves as EW, who says, do you think there's a risk that interpreting Article 51 as justifying non-forcible measures could lead to a gradual erosion of the armed attack requirement? So states may reason backwards that non-forcible measures are proportionate to low-intensity armed attacks or imminent attacks because it sits at the bottom of the spectrum, where escalation to forcible measures for more grave armed attacks is still possible.
Anyone that's familiar with the law of self-defense and the state practice around that and the literature around that knows that there have been quite considerable efforts to expand self-defense. You can think of preemptive self-defense, non-state actors, and all these different issues. Some of those arguments I agree with, and I've written about. Some I disagree with, and I've provided my own reasons. I mean, in my view, it doesn't create that risk. You hold the line, and if an armed attack is defined in a particular way, the ICJ has consistently interpreted it as a grave use of force. And yeah, you hold the line, you maintain that. And I don't think expanding self-defense to cover non-forcible measures poses any particular risk there. So yes, I said towards the end of my presentation, I'm really keen for people not to read this and say this is kind of part of a gung-ho policy to ratchet open Article 51. Those other restrictions that ensure that self-defense is used exceptionally in a limited way and subject to Security Council oversight. I don't touch those, and I agree with all of those different restrictions. As I say, I actually think this can be a vote for peace insofar as it can help de-escalate crisis.
Thank you. Any other questions in the room? I'll take one more question online from Renee. The question is really about whether there would be value in trying to create more legal certainty in this area, more explicit rules governing what non-forcible measures could be adopted in self-defense in what circumstances, and what would be the most appropriate means of achieving that that sort of greater certainty, I suppose, beyond your article.
So it's interesting, so Malcolm is sat there. I thought about this topic back in 2004 when I was an LM student at the University of Bristol, and the advisory opinion, in the Wall advisory opinion, which rendered. So to us, Israel's relying upon self-defense, but clearly the building of wall is a non-forcible measure. I'm reading Dinstein, I'm reading Gray, and they're saying that it can only be engaged in relation to uses of force. And I didn't really, couldn't really understand it properly at that time. So, and really since then, I've been thinking about this, and it's really been kind of percolating through my mind. Actually, this article was a product of lockdown. During lockdown, I decided to use my time wisely to finally put pen to paper. And to a certain extent, I think the argument is being pushed forward by cyber. You see these strategies of active cyber defense, which is not just local to one particular state, but several states have put that forward. And of course, you have persistent engagement, defend forward, that have been put forward by other states. Yet at the same time, you can see that many states are very concerned about how you define a use of force in cyberspace. So as I say in the paper, the reality is that many of those cyber operations may be unlawful, non-intervention, even a breach of sovereignty, depending on one's view of the sort of the ontological status of sovereignty. And then how do you justify it if it's in response to an armed attack? If a state is subject to an armed attack and it wants to conduct cyber operations to take down certain systems, to delete certain data belonging to the aggressor state, all part of repelling the armed attack, then I think cyber is going to really sort of push the envelope on that.
It's very interesting. We often see arguments for the distinctiveness of the cyber context, and the dangers that it poses as a precedent. But I think you're making a kind of counter argument that actually could be a valuable context in which this broader principle crystallizes.
Yeah, and so I certainly think it brought it to the fore of my mind, as I said. It was really the defend forward strategy when I thought, okay, there's something very important here. I need to revisit my LLM work from the University of Bristol. I do want to stress that if you're prepared to look closely enough at the state practice, at the doctrine, at the discussions in the Security Council, and in the article, I go into things a lot more detail, and I worked quite hard and did quite well to find state practice, for example, around the Argentinian war, the Falkland Islands war, to show that many commentators were saying this is countermeasures, collective countermeasures. When I looked at what Canada and what Australia were saying, and other states in defence of the UK, the various restrictions that they imposed, they weren't saying countermeasures at all, as you saw from the quotation. It was very clearly this is self-defense. And even prior to 1945, self-defense has always been engaged to justify non-forcible measures. Not often, self-defense is often engaged in the context of force, but there are many other wider examples of non-forcible measures. So yeah, cyber is important, it's pushing things forward, but the genesis of this idea really is contained in much wider state practice.
Brilliant.
But also logic. There's a logic that if you can take force to defend yourself, you must be able to take non-forcible measures.
Absolutely. If there aren't any more questions, then I think we'll probably bring proceedings to a close there. Before I ask you to join me in congratulating our prize winners and our annual lecture giver, just a brief announcement. So for those interested in reading more about these issues, Lewis's article is open access, and so it's freely available to everyone. But Cambridge University Press are going to make Russell's article available open access for a month from today, so people can who don't normally have access will be able to download and read it as well. So for those of you who haven't read it, of course, I encourage you all to do so. And so it only remains for me to thank Russell and Lewis, and congratulations to you both again, and to invite you all to join us for a drink afterwards.